Okay, so good morning everyone. Good morning. A very good morning to everyone. Okay, I hope you are very and you will be very attentive in the lecture. It is not just your switched it on, locked in, and you're now sleeping, having breakfast. Okay. Now let's understand. Okay. So guys, yesterday we finished up till a point which was nothing but uh, I think dishonor of check we finished. Yes. Now there is one important word which we need to understand, that is delivery. See, be it a bearer instrument or a order instrument. A bearer negotiable instrument's ownership can be transferred by simple hand delivery, and basically order instrument by endorsement and delivery. That one thing we understood, that sir, delivery is very important. Without delivering the instrument, ownership is not transferred. Yes or no? Now, what do you mean by delivery? Delivery means transfer of possession. Yes or no? Simple. Now, delivery you have studied in sale of goods act. In fact, we'll be today we'll be doing sale of goods act. There I'll properly tell you that there are three types of delivery. One is actual delivery. Okay. One is symbolic delivery, and one is constructive delivery. But here under, see, for sale of goods act, delivery can be of three types, but here that can be only actual and constructive. Actual means basically actually giving the instrument. I give the check to you physically, actually change of hand. Symbolic is not there here. Constructive means I, rather than giving it to you, I give it to your authorized agent, okay, as directed by you. Okay, that is deemed delivery. Am I clear with this thing? Understood? So that is constructive delivery. So without delivery there cannot be transfer of ownership. So delivery is very important. Now, important point, that was, sir, in case Mr. X made a promissory note in favor of Mr. Y. I promise to pay 1 lakh to Mr. Y. Mr. Y negotiated, endorsed it, okay, to Mr. Z. You know, endorsed to Z. But beta, he did not deliver, okay, it to Z. Before delivery, Y died. So basically, is the ownership transferred here? Answer is ownership is not transferred to Z. Ownership is not transferred to Z. Am I clear with this thing? That means beta, now can Y's legal heir do the delivery and negotiate the instrument? No. Can Z claim that it is written endorsed to Z? Okay, can Z claim and claim that check? No. Okay. Endorse means you write it, endorse to, that's it, and sign, endorse to Z, and basically sign it, that's it. That is endorsement. Am I clear with this thing? Understood? Okay. Now, this was about delivery. This was the main part of delivery. Now comes a very important point. Not very important as such, but yes, questions are asked. That is presentment of instruments. Negotiable instrument. Now, understand. First, I'll tell you the simple part and then the technical part. Okay. Now, understand. See, sir, if there is a promissory note, the different instruments I'll write. Okay. promissory note payable certain number of days after date. I promise to pay Mr. X 1 lakh rupees 10 days after date. So basically Mr. X will give that instrument to Y. Now Y on the due date has to present it for payment. This instrument has to be presented for payment. Is it required to be presented for acceptance? No. Why to present it for acceptance? Second, promissory note payable on demand. I promise to pay Mr. X so and so rupees on demand. So that also beta is a promissory note which basically Mr. X will give it to Y. Y will anytime can come and present it, okay, for payment. This is also required to be presented for payment. For acceptance, it is not to be presented. Next, third comes promissory note payable certain number of days after sight. Means here X, okay, writes I promise to pay Mr. Y or his order a sum of rupees 5,000 10 days after sight. So 10 days calculation will start from where? X will give the note to Y. Okay. Now Y may endorse it to someone else. Okay, I am not taking it, it is that he has endorsed it. Same implications will come while endorsement. Y has to present the instrument to X again. Okay, and then beta, so that is presented for acceptance, kind of acceptance here. Now X will accept it. Okay, it is presented for acceptance. Okay, now he will give it back to Y. Now beta, the 10 days will start after sight. When it is presented for acceptance, from there beta 10 days will start. Okay, so basically first there is a promissory note payable certain number of days after sight has to be presented for acceptance. Okay, he presented for acceptance, Y will present it, and from the day he is presented 10 days will start, and after 10 days beta Y will again present it for payment, then payment will be made as well as for payment. Correct? Now okay, next is bill of exchange. Bill of exchange has to be presented for acceptance plus for payment. Correct? The third one is check. Yes, check is to be presented for what? For acceptance. No, bank doesn't have to accept, bank has to make payment only. Okay, for payment only. Okay, so can I say all instruments have to be presented for payment, but promissory note payable after sight and bill of exchange has to be presented for acceptance also. Am I clear? Understood? Okay. Now first thing to beta, people don't understand the meaning of this word presentment. People think presentment means just presenting the instrument for acceptance or payment. No, presentment means what, you know? Presenting the instrument as per directions given. Okay, like example, if X writes, I promise to pay, we'll take example of bill of exchange, okay, or promissory note also same. X tells, I promise to pay Mr. Y a sum of rupees 1 lakh 10 days after sight. Now Y has to present, Y has to present the instrument for acceptance also. So when should Y present the instrument to X for acceptance? It will be as per the directions of X. Okay, and directions will be regarding date, time and place. So X tells on Tuesday, okay, 5th January, example the date is 5th January, Tuesday, present the instrument to me for acceptance, okay, at 4 p.m. in my office. So Y has to present it, okay, as per the directions given. That is called presentment. If you don't present the instrument as per the directions, okay, then beta, can you claim payment on it? Answer is no. Did you understand this thing? Same for bill of exchange. The A drawer draws a bill on B, okay, that's pay to C. Now B will say, hey boss, you present the instrument to me as per my directions for acceptance. Drawer has to present the instrument as per the directions, or else beta, the instrument is dishonored. B is not liable to make payment. If you understood this thing, give me a thumbs up quickly. If you understood this thing, give me a thumbs up quickly. Yes? Okay. So, now, good. Okay. Now there are rules for presentment. Okay. So now we'll do from here, the book. This much you understood, now we'll understand everything. The presentment for acceptance. A bill of exchange payable after sight. Pay to Mr. X. So sum of rupees, like example A, draws a bill on B and tells pay to C. Pay to C a sum of rupees 1 lakh 10 days after sight. So now first A has to present the bill to B for acceptance. When he has to present a bill, if any directions are given, then present it as per the direction. Direction will be regarding day, time and place. If no directions are given, you have to present the instrument within reasonable time. Am I clear with this thing? Understood? If you don't present it within reasonable time, then beta, the instrument is dishonored. You cannot claim payment. Sir, if you try to present it, but the person cannot be found, then beta, B cannot be found. So it is dishonored in favor of A. Now wherever B can be found, beta, A will can directly file a suit on B. Am I clear with this thing? A bill of exchange payable after sight, if no time or place is specified, means no directions have been given for presenting the instrument for acceptance. Be presented to drawee thereof for acceptance if he can after reasonable search be found by a person entitled to demand acceptance within reasonable time after it is drawn and in business hours on a business day. Am I clear with this thing? So no directions are given. During business hours on a business day within reasonable time you have to present. In default of such presentment, no party thereto is liable to the person making such default, obviously. Am I clear with this thing? So you can't claim payment now. Understood properly? Okay. So now A cannot claim payment from B, C cannot claim payment from B. Understood? If the drawee cannot after reasonable search be found, the bill is dishonored. B cannot be found, the bill is dishonored. If the bill is directed to drawee at a particular place, if directions are given as to place, then you have to present the instrument for acceptance at that place. It must be presented at that place, and if the due date for presentment he cannot after reasonable search be found there at that place, B cannot be found, and the bill is dishonored. Am I clear? Next line, where authorized by agreement or usage of presentment through post office by means of registered letter is sufficient. Generally what happens, A has to personally go and present the instrument. But beta, in case A and B stay very far away and they have agreed that A may present the instrument through post, he'll post it B has to accept it, and B is like, okay, no problem. So presentment through post is also okay. Am I clear with this thing? Understood? If you understood, give me a thumbs up quickly on this point. Quickly. Great. Now let's say next, presentment of promissory note payable after side. X, right, I promise to pay Y a sum of rupees 1 lakh 10 days after side. So Y also has to present to X the instrument for acceptance. If directions are given, then as per direction. No directions are given, then beta within reasonable time on business hours, during business hours, on a business day. Same thing. A promissory note payable at certain period after side must be presented to maker thereof for site, if he can after reasonable search be found by a person entitled to demand payment within reasonable time after it is made in business hours on business day. If you do not present it for acceptance as per the directions or within reasonable time, if no directions are given, then no party is liable. So X is not liable to Y now. Clear? Okay. The next, section 63. Sir, if X draws a bill on Y, okay, and presents the bill properly, okay, Y has to give acceptance. So Y has to give acceptance within what time? Answer, within 48 hours. Within what time? 48 hours. If within 48 hours he does not present the bill, sorry, he doesn't give acceptance, then beta the instrument is dishonored on account of non-acceptance. I hope I'm clear with this. Yes, yes, yes. Okay. Next, presentment for payment. Now, what is presentment for payment? I told you, be it any instrument, every instrument has to be presented for payment. But here presentment means what beta? Presenting the instrument as per the directions. If you do not present it as per the directions, okay, then can you claim payment? Answer is no. Okay, so see, promissory note, bill of exchange and check must be presented for payment to the maker. Promissory note to the maker, bill of exchange to the drawee, and check to the bank. Okay, in default of such presentment, other parties thereto are not liable. But if it is agreed, presentment through post is also okay. Generally personally you have to give, but through post is okay. Now one exception is there, where a promissory note is payable on demand and is not payable as a specified place, no presentment is necessary in order to charge the maker thereof. Now see, X writes, now what is this? X writes, I promise to pay Mr. Y a sum of rupees 10,000 on demand. Now Y has to present that instrument to X. Presenting is important, but what is written by the exception? Presenting the instrument is required, because without presenting the instrument to X, how will he make payment? But presentment is not required. Now what is presentment? Presentment means presenting the instrument as per the directions. Now directions are regarding to three things: day, time, and place. Now beta, tell me, it is an instrument which is payable on demand, so there is no direction as to day and time. Plus beta, there is no direction as to specified place, no direction as to place of presentment. That means beta, here Y can present the instrument to X. Okay, he has to present it within reasonable time, obviously, for payment. Okay, but is there any specified place mentioned? No. So no place is mentioned. There is no direction as to day, time, and place. So he can present. He has to present it. Okay, within reasonable time, obviously during business hours on a business day, but at any place. No place is given. So is there any directions given? No. If there is no directions given, you have to present the instrument. But are you required to do presentment? Because there is no direction as to day, time, and place. Here, everyone. Understood? Okay. The next part is not that important. Okay, so we'll directly go to the next section. Hours for presentment. Sir, obviously, for payment beta, okay, you have to present during business hours. We know that thing. If no directions are being given during business hours, and if it is a check, promissory note, bill of exchange, business hours. If it is checks during banking hours, you have to present for payment. Simple. Now, Clear up till section 65? Okay. Next, presentment for payment of instrument payable after date or site. Like example, if you want to calculate the maturity period, okay, so how we do it? Example, a bill payable 5 days after date. Okay. Drawn on 1st June 2025. So what will be the, how to calculate the maturity date? 1st June plus 5 days. 2nd, 3rd, 4th, 5th, 6th. 2nd, 3rd, 4th, 5th, 6th. 6th June plus 3 days will be the grace period. So you will get payment on which day beta? 9th. But you have to present for payment like A draws a bill on B, pay to C a sum of rupees 1 lakh 5 days after date. So C has to present on which date beta? 6th. But he will get payment on which day beta? 9. So basically B has to make payment on 9, but C has to present it on which day beta? Take a 6th. A promissory note belongs to section made payable at a specified period after date or site must be presented for payment at maturity. So here basically take a 6th. But here the things change. Presentment for payment of promissory note payable by installments. Means example, it is written pay to Mr. C. A is telling B, Mr. C, a sum of rupees 1 lakh in 10 installments of rupees 10,000 each on 10th of every month. Okay, you're paying in installment. So here Mr. C has to present the instrument 10 times, but when he is required to present the instrument? Here better the date fixed, okay, plus better 3 days grace period will be there. So in this case better you don't have to present on 10th, you have to present on 13th. Am I clear? If it is one time, then basically the date, whatever, like here 6th you have to present, but here better whatever the date is fixed plus 3 days. Okay. A promissory note payable by installment must be presented for payment on the 3rd day after the date fixed for payment of each installment. Am I clear? If you do not if you present it and the payment is not made, it will be deemed to be dishonored. Clear everyone? Understood? Next, section 68 and 69 more or less same. Sir, example, X tells Y, he was present the instrument to me for payment, okay, at CCD Bangalore on 5th August. I'll make the payment. So basically now Y has to present the instrument to X at CCD Bangalore. Can he present it anywhere else? No. If he presents it anywhere else, so obviously X is not bound to make payment. That is section 68 and 69. Promissory note, bill of exchange, check made, drawn, accepted, payable at a specified place and not anywhere else must, in order to charge any party thereto, be presented for payment at that place only, not anywhere else. 69 is also the same. Now what does section 70 does? Sir, if he has not specified any place, it will present the instrument to me on 5th August, okay, for payment. So basically if there is no place mentioned, then basically you have to present it at his place of business or residence. Place of business or residence. So basically here. A promissory note, bill of exchange not made payable as mentioned in section 68 and 69 must be presented for payment at place of business, if any, or at usual residence. Sir, section 71, what does it tell? Section 71 tells that boss, yeah, sir, if that person doesn't have any place of business or residence, he doesn't have, then basically you can present the instrument to him, okay, wherever he can be found, wherever is found, okay, you can present during business hours, okay, on a business day. Am I clear with this thing? Example on 5th he told you present it, so wherever he can be found you can present it. Generally it will not happen. So basically, if maker drawer of negotiable instrument has no place of business or fixed residence and no place is specified in the instrument for presentment, such presentment may be made to him in person wherever he can be found. Am I clear with this thing? No, Samiksha. Try to resemble it. Exact words nobody can write, to be honest. No one can write exact words. Just try to resemble it. Okay. So case laws, wherever, see, hardly I'll tell you now, 20-25 case laws you have to remember. It is as good as better 20-25 short answers you have to remember. That much so by head we can do, yeah. Simple. In your college also 20-25 answers you are by hearted. That much we can do. Okay. Now section 70 to 73, I don't think they'll ask. Okay. So I'm not, for the timing in crash course I'm not taking it, okay, because it is connected to some other section, section 84, which is not in your syllabus. So probability of asking is less, but in case you want me to explain it, take care, you people or YouTube people, just drop a message. I'll make a separate video and send it to you. Don't worry on that. How long should it be? Can we summarize it in few lines? Yes, you can summarize in few lines. No problem. Next, section 75. Sir, X tells I promise to pay Y a sum of rupees 10,000 10 days after date. So Y had to present the instrument to whom, beta? X, correct? But in case X has an authorized agent, so you can present it to the authorized agent. Then in case X died, can you present it to the legal heirs? Yes, you can present it to legal heirs also. So see, presentment for acceptance or payment may be made to the duly authorized agent of the drawee maker acceptor, or as the case may be, where the drawee maker acceptor has died, to his legal representative, or he has been declared insolvent, so his court person, because official assignee we call him. Okay, so basically example, X is declared insolvent, so one court person will be appointed by court to sell his asset, pay the debts. So you can present the instrument to that official assignee. Okay. Next, excuse for delay in presentment for acceptance or payment. Sir, what did I tell you, sir? If there is no time mentioned, there is no direction given as to presentment of the instrument, you have to present it within reasonable time, correct? If you don't present it within reasonable time, okay, then obviously the instrument is dishonored, you can't claim payment now. Yes or no? Now, but in case you were not able to present the instrument within reasonable time because of certain reasons which were beyond your control, they were not within your control, then it is fine, okay, you can present it later on, no problem. So I'll give you an example. Okay, Madras High Court recently gave a decision, beautiful decision, that one person had to present the instrument, but he did not present the instrument because, or within reasonable time, because his father was ill and this guy was busy in his father's ailment in the hospital. So court told, Madras High Court told, no problem, these are reasons beyond his control. So whenever his father will be discharged, from that time a reasonable time will start. Am I clear? Delay in presentment for acceptance or payment is excused if the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct or negligence. When the cause of delay ceases to operate, presentment must be made within reasonable time from there. Okay. Next, when presentment is unnecessary, this question has been asked 2-3 times. Okay. Now understand. Sir, what is it this point tells? Sir, there are few circumstances where the person who has to present the instrument and take payment If there are these circumstances happen, then beta after these circumstances he doesn't have to again present the instrument. He can directly claim payment from the party. Okay, he can directly sue the party for payment. So which are the situations? Okay, no presentment for payment is necessary and the instrument is dishonored at the due date for presentment in any of the following cases. First, if the maker, drawee, acceptor intentionally prevents the presentment of the instrument. I told you to come at my office and present the instrument to me for payment. On that day, beta, I did not allow you because of my security guards. I did not allow you to come inside on that particular day. Told no, sir is busy, sir is busy. So basically, it is my default. After that, are you required to present the instrument to me? No, you can directly sue me for payment. If instrument being payable at his place of business, he closes such place of business on business day during business hours. That means, beta, I told you to come and present the instrument in my office during business hours. I closed that office on that day. It's my mistake. Now, beta, will you present the instrument? No, you can directly claim payment. If instrument being payable at some other specified place, neither he nor any person authorized to pay it attend such place. I told you to come to CCD Bangalore, this address, and present it for payment. Neither I came, neither my agent came during business hours. You were waiting for me. Now you can directly sue me. If the instrument not being payable at any specified place, okay, he cannot after due search be found. I told you 5th August, I'll contact you, come at that place and present. I did not call you. 5th August you called me. After that 6th August you are calling me. I cannot be found only. So now you can directly sue me. Okay. As against any party sought to be charged therewith, he has engaged to pay notwithstanding non-presentment. Means example X told Mr. Y that boss, you present the instrument to me. Okay. He told ki present the instrument. Okay. 10,000 I'll pay to you. Present the instrument on 5th August. Am I clear? Basically, Y has to present the instrument as per the direction. But X also told this is just a official statement. Okay, you're not required to follow it. Okay, I told you have to come at 4 p.m. You come at any time during business hours, I'll make payment. So obviously, beta, taken now, beta, there is no direction just to presentment. So basically, X is telling Y to come at any point of time and make the payment. Present the instrument, I'll make the payment. Now Y went at 2 o'clock to present the instrument, and X beta is not paying. So can Y sue him? Answer is yes, obviously, because he only told her you, I'll make the payment irrespective whether you present the instrument or not. Okay, now you are not making payment, it is your default. Okay. As against any party, if after maturity with the knowledge that the instrument has not been presented, he makes a part payment. Like example, Y did not present the instrument, okay, as per direction. But beta 10,000 was the amount. Now X comes to know he did not. But what X does? X makes payment of 5,000. No problem. I'll make payment. So as he made 5,000 ka payment, so he has accepted that, boss, I'm ready to pay, irrespective whether you have presented the instrument or not. Now he is liable to pay for the next 5,000. Okay. He had a right not to make payment, but the moment he made part payment, then beta there itself beta is stating the contract valid. Okay. Or promises to pay the amount due thereon, means Y did not present the instrument at 4 p.m. okay, as per direction, but X informed Y that boss, you did not present the instrument. Okay, no problem, I'll make the payment, then I'll make the payment, but after 5 days. So now beta he had a right not to make payment, but he promised that he'll make the payment. So obviously now he is bound to make the payment. Okay, Y can directly sue him after 5 days. Or otherwise waives his right to take advantage of any default. Like X tells Y, I know you are not presented, but don't worry, I will not misuse this thing. Okay, don't worry. Okay, I am bound to pay you and I'll be making payment. So same thing. Okay, second or third point is more or less the same. So basically, if you make part payment or basically you promise to pay, even if the person did not present the instrument, so you yourself are forfeiting the right not to make payment. Then you are bound to make payment. Afterwards, Y is not required to present the instrument to you. As against drawer, if the drawer could not suffer damages for want of such presentment. So this happens in case of cheque. Example, A gave a check to me Harsh, today, what is today's date? 26 November. Okay, writing the date 26 November only. I did not deposit it today, but I deposited it after 2 days. Is it fine or not? Yes. But what happened? The day when I deposited the check, that day itself, beta, okay, what happened? His bank got bankrupt. His bank got bankrupt. Okay. Now tell me, okay, is it my mistake here? Is it my mistake that his bank got bankrupt? Answer is no. Now, beta, my check is dishonored. Can I claim payment from him? Can I directly sue him? Yes. I don't have to again, beta, take another check from him. Directly I can sue. But what the law tells, okay? Example, beta, on 20th November I did not deposit the check. I deposited the check, beta, on after 2 months. So it is within the legal time, but it's within the validity time. But is it reasonable time? No. So basically after 2 months if I deposit the check, it is my ignorance, and in between that, beta, if his bank goes bankrupt, then I can't sue him. Am I clear with this thing? So this point tells that, boss, I deposited a check within reasonable time only, in 2-3 days in my week, and before that his bank got bankrupt. Okay, so basically I can directly sue the drawer of the check, basically the person who gave me the check, for payment. I will not present the instrument. But if I deposited after reasonable time, after 2 months, 2.5 months, but in between, okay, the check, okay, his bank got bankrupt, then I can't claim payment. Understood? Clear? Did you understand this point? Give me a thumbs up if you understood. It is important to attempt full 100 marks in the exam. Yes, that is obvious question. Okay, an obvious answer. Have writing practice. Do not leave anything. See, generally people who get 38, 36 and all, know what they tell, sir, I too attempted 80 marks ka paper. Obviously, if you would have attempted 20 more marks, after 20 at least 6-7 marks you would have got, rather than 36, 37, you might have ended up with 43, 45. Simple, है ना? So try to attempt all the 100 marks paper. Okay, so one more example I'll give of this. A gave a check of 26 November and it will give you deposit, okay, tomorrow itself. But I deposited next day. But what happened, beta? Okay, before my payment, somebody else had, or you can, somebody, like example, A gave a check to me, Harsh, of 26 November. Okay, and he told, sir, deposit today itself. But generally the legal time is 3 months. I deposited on 28 November. Now my check got bounced. Now here, what is he telling now? Sir, I told you to deposit on 26, because I knew on 27 my EMI will come and the money will be deducted. Okay, so why didn't you deposit it? Now I'm not bound to make payment. Is he bound to make payment? Yes, because did he suffer any damage because I did not deposit the check on 27? No, he did not. His EMI went off, which he was bound to pay. So basically, now can I directly sue him? Answer is yes. Did you understand this point now clearly? Yes. Next, liability of banker for negligently dealing with bill presented for payment. Beta, this bill of exchange here also they are talking about check. This we have done this thing. I'll tell you. Do you remember, beta, in Contract Act there was a concept of damages? Yes. And basically now that damage, where there were types of damage. In that there was one type of damage, exemplary, punitive, vindictive damage. These are the damages for loss of reputation. Yes or no? Okay, now these damages are given only in 2 cases. First, breach of promise to marry, and second, okay, wrongful dishonor of check by bank. Okay, so now what is this point? See, example, Mr. A. Okay, Mr. A, मैं अपना example लेता हूँ. Mr. Harsh, I gave you a check, okay, of rupees 1000, okay, to X. You are X. You deposited the check in your bank, SBI. SBI presented the check to my bank, ICICI. Now I had money in my bank. but then to beta my bank na negligently dishonors the check telling ki boss I don't have money in my account. So obviously ठीक है, here under exemplary of vindictive damages I can sue my bank for loss of reputation. But you know beta, when this check is bounced, so your bank also charges you, example 500 for dishonor of check bouncing. So can you beta take this 500 rupees from the bank? Answer is yes. Which bank beta? ICICI Bank. This is section 77. Okay, so if the bank negligently beta dishonors the check, so you had an expense of 500, so basically the bank must compensate the holder for such loss. Am I clear with this? Understood? Clear? Okay, if you understood up till now, give me a thumbs up quickly. Quickly give me a thumbs up. Okay, good. CA aspirant, you did not understand this point. Which point you didn't understand? Which point? Just type it, okay? I'll come to you. Now, rules of compensation. Now, what is rules of compensation? I'll tell you. See, I mentioned it. CA aspirant, yes or no? What you understood or not? Understood. My mistake, okay. See, rules of compensation I have written here. There are basically section 117. There are 4 points, 4 to 5 points. Okay, so I'll tell you what is this. See, example. I gave a promissory note to Nora Fateh, and I wrote, I promise to pay Nora Fateh a sum of rupees 1 lakh 10 days after date. Okay, but what I did, I dishonored the check. I dishonored the promissory note. Okay, now Nora Fateh can claim from me what all things, because I did wrong. It's kind of breach of contract. She can claim from me amount of promissory note 1 lakh plus interest of 18% per annum plus noting charges plus protest charges. Now what is noting? Maybe Nora Fateh has to file a suit on me. First she'll go to a notary public lawyer and tell this things happened. This Harsh dishonored my check, dishonored my promissory note. So he will write in his register the details of dishonor. That is called noting. Okay, some courts accept noting as a document, okay, for instituting a suit, but some courts don't accept. So in that case, beta, protest is required. What is protest, beta? After the notary public writes in his records register the details of dishonor, he will issue a certificate under his hand. In that certificate, the details of dishonor is written. That is protest. Because all courts accept protest. Some courts may accept noting only. Okay. So basically, if you have done noting and protest both, then you can charge. She can claim noting charges plus protest charges. Okay. Understood. Now, beta, how now she has a right. Okay. Example, this whole amount. Okay, 1 lakh plus 18 plus 10. This is example 1 lakh 10,000. Now, what she can do for claiming that payment against me? First option, she can directly sue me for that 1 lakh 10,000, or she can draw a bill of exchange of 1 lakh 10,000 payable on demand on me. So basically, Nora Fateh will write, pay to me a sum of rupees 1 lakh 10,000 on demand. I have to accept and make payment. Okay, understood? So these both options are there with her. But when she chooses this option, okay, she has to attach that promissory note, okay, which has been dishonored, a copy of that. Okay, when she gives the bill of exchange to me. Okay, at that time promissory note copy should also be attached. These are the two main points. Now what is the third point? Example, Mr. Johnny is in USA. Okay, and Mr. Rocky is in Russia, and I am in India. So he gives a promissory note to Rocky. I promise to pay $10,000 to Mr. Rocky or his order 1 month after date. Now Rocky endorsed that instrument to me. Now first option, beta, I will present the instrument to Johnny. If he pays, well and good. If he doesn't pay, then I'll tell you, then obviously I can sue. But if Johnny pays to me, will he pay me in dollars or he'll pay me in rupees? Answer, he has to make payment in rupees to me. Am I clear with this? Okay. But in case I claim payment from this guy, okay, will he make payment in rubles? Russia's currency is ruble, or in rupees? Answer is in rupees. Am I clear with this? Now, sir, example, okay, I wrote Germany, na, okay, no problem. He is in Germany, okay, or he is in Russia, whatever it be. Okay, I'll take Germany. In Germany, euros are there. So basically, example in this case, I claim payment from Johnny and he did not make payment. Then I claim payment from Rocky. So Rocky made payment. He makes payment in rupees. But now beta, Rocky will claim payment from Johnny. Now Johnny has to pay in what beta? In dollars or in euros? He has to pay in euros. Am I clear with this thing? Understood properly? So he'll make the payment plus interest. Understood? Okay, interest prevalent in USA. Understood properly? So example, in USA it is written, if you dishonor the check or a negotiable instrument, you have to make payment along with 10% per annum. So basically Johnny will make the whole payment plus interest of 10% per annum to Rocky. Understood properly? Clear? Everyone? Okay. So this is where Negotiable Instrument Act presentment part also comes to an end. Understood? Did you understand these points? If yes, give me a thumbs up quickly. We understood? Yes? Okay, so great. This lesson is done. We are shifting to Sale of Goods Act, a new lesson. So what I'm doing, I'm giving you just 2 minutes break, just 2 minutes. Okay, because we are shifting to a new lesson. That's the reason. Just 2 minutes. If you want to have tea and all, you can have in 2 minutes. Okay. Just 2 minutes. Okay, so okay, guys, let's start. See, now we are starting with Sale of Goods Act 1930, SOGA. So, in the year 1930, one act was passed to govern and regulate sale of goods in India. Correct? This is the basic purpose of this act. Now, guys, Sale of Goods Act was initially a part of Contract Act. The provisions of sales were a part of Contract Act. Then it was separated and made a new act, okay, in 1932. Understood? Now, so sir, this act is passed to govern and regulate sale of goods. So answer beta, understand, this act will come into picture whenever there is sale of goods. Only when beta goods are sold, this act will come into picture. Sir, for the time being, what do you mean by goods? Movable property. For the time being. Okay. Now, whenever there is sale, so that means, sir, in case if I sell immovable property, will Sale of Goods Act come into picture? No. Now, sir, sale means what? Sir, whenever I am telling my intention is to do sale. So, what is my intention here? My intention is to transfer ownership. So, whenever one person transfers ownership in his goods to another person, then it is called as sale of goods, and that transaction will be covered under Sale of Goods Act 1930. Okay, everyone understood clearly? Now, sir, can I say sale is nothing but a contract? Yes. So, sir, can I say that, can I replace better sale with the word contract of sale? Yes. So, today if I tell my lawyer, yeah, I have entered into contract of sale and advise me on this, first thing he'll ask me whether you have done sale or agreement to sell. Sale or agreement to sell. So, contract of sale can be either sale or agreement to sell. Heart of this lesson. Okay. What do you mean by sale? Sir, when can I say that I have done sale? Beta, sale implies transfer of ownership, correct? So that means beta, take if I say I have done sale, so the ownership, the intention is already achieved. The ownership in the goods transfer from the seller to buyer at the time of contract. That is called as sale. Ownership of goods is transferred at the time of contract. Maybe beta price will be paid later on, credit sales we say, but ownership is transferred at the time of contract. So the purpose is achieved. It is executed contract. Example, buying biscuits from shop. Immediately the ownership transfers, yes or no? That is sale. What is agreement to sell? Sir, agreement to sell means the ownership of goods is not transferred at the time of contract. It will be transferred at a future date, subject to fulfillment of such conditions or payment of price, say. Okay, it is an executory contract. I'll give you example of this. Example, Mr. Harsh, I have a bike for sale. I show the bike to Mr. X. He is a known person, friend. He sees the bike and he is like, which bike better? We'll talk about being rich. I have a bike, Hayabusa. Example, I don't have. He saw the bike and he decided to buy it. I told price is 15 lakhs. He gave me a check. I told, Are yaar, you are giving me check yaar. Like, sir, a check will be passed, don't worry. I told, okay, you give me the check, I'll deposit when it honors, then you take the bike. He's like, sir, today I have promised my friends that I'll bring this bike. Thoda show off, sir, I had to do, sir. I'll be insulted. Okay, do one thing. You take the bike, but I will not transfer ownership today. I will transfer ownership when the check is passed after 3 days. He's like, okay, no problem. So see, here at the time of contract, did the ownership transfer? No. It will transfer at a future date. So that is called as agreement to sell. Okay, everyone. Now, I hope you understood sale and agreement to sell. Now, it is very important for you people to understand this thing. The definition is of contract of sale. What is a contract of sale? It is a contract where one person, that is seller, transfers or agrees to transfer. Transfer means sale, agrees to transfer means agreement to sell. Property, ownership in goods to another, that is buyer, for price. What is price, beta? Money consideration. Am I clear? Without price, okay? See, price is required in a sale, but is it to be paid at the time of contract? No, it can be paid at a future date also. Okay. Sorry. Now, example, X gives rupees 1 lakh to Mr. Y and takes mobile from him. Is it a sale or not? Yes, it's a sale. Second, X gives his laptop to Y and takes his mobile. Is it a sale? No, it is not a sale. Why? Because it is barter. Next, X gives his laptop plus rupees 1 lakh to Y and takes mobile. Is it a sale? Yes, because beta 1 lakh money consideration came now. Did you understand? It's a sale. Like we do now. We give our old car, we go to the showroom to buy a new car, we give our old car, they give us exchange money, and we say additional money we put, and then take a new car. Is it a sale or not? Yes, it's a sale. Simple. Okay. Now, okay. Now, I hope you understood sale and agreement to sell. Now, this act will come into picture whenever beta the subject matter is goods. Now, sir, what is the definition of goods? See, beautiful definition they have given. Goods means every kind of movable property. All movable properties are goods, except actionable claims and money. They are not goods. Money is not goods, beta. From money we buy goods. Money is not goods. Correct? Okay. Actionable claim is a right over money. What is it? Right over money. Like example, Mr. X gave a loan to Y of 1 lakh and Y promised that I will pay you after 1 month. So can I say X has a claim of 1 lakh rupees against Y? Yes. An example, Y fails, so X has a right to take action for his 1 lakh, like right to file a suit, sell Y's property and recover the loan. Yes. So this right to claim money is an actionable claim. This right, beta, X can transfer it to Z, to A, to B. He can transfer it. Z pays 1 lakh to him, and X gives the right to him. This can be transferred. But as it is a right over money, okay, and money is not goods, so this actionable claim is also not goods. Am I clear? And includes shares and stocks. Shares and stocks are goods. Many people will be like, sir, shares and stocks, so basically they are not movable. You tell movable things are goods. But example, if I am selling you crops, will I sell it to you along with the land, or I'll cut it from the land? Cut it from the land and give it to you. So all those things which are removed or agreed to be removed before sale from the land, all those things beta will be goods, even though currently they are attached to land. Am I clear? And growing crops, grass and things attached to or forming part of the land which are severed, that is removed or agreed to be severed before sale or under contract of sale, all these things are goods. Am I clear? So what is goods, beta? All movable properties. Okay. And basically actionable claims and money is not goods. Grass and growing crops are goods. All things which are attached to land, but before sale they will be removed and sold. All these things will be goods. The fruits, vegetables, all will be goods. Acha, guys, tell me, Patents. Will it be goods? Will it be goods? Patents, copyrights and all. Intellectual properties, will it be goods? Answer is yes, they are goods. Okay, patents, copyrights, everything are goods. Next, if I say, okay, a big ship, big ships are there now, in which the whole city is there. Okay, people, restaurants, cafes and all. Is ship goods? What do you think? Is it ship goods? Answer is yes, ships are goods. Okay, even though better because it is movable. Acha, now you tell me, water, is it goods? Water, what do you think? Water is goods? Yes or no? Water is goods or not? No. Answer beta, there are some things like water, gas, electricity. It depends upon which form we are taking. Like example, that tap water which you get in your home, that is a service from government. You pay bill for that, I accept, but it's a service, it is not goods. But example, when you buy bottled water, distillery, mineral water, okay, then beta those things are goods. Am I clear with this? Then water is goods. Acha, old coins, old rare coins, which are not in circulation now, 1 paisa, 2 paisa, it is not in circulation. Old coins, gold coins, okay, will it be goods? Answer is yes. These are not in circulation now, so they will be goods. Am I clear with this? Understood? Okay. So this part we understood. Now beta, classification of goods, very important. Very, very important. If you don't understand this thing, unit 3 you will not understand. There are 4 units in this lesson. Okay. Classification of goods. There are 3 types of goods, understand. One is existing goods, future goods, contingent goods. Now what do you mean by existing goods? Existing goods means the goods which are either owned or possessed by the seller at the time of contract. Owned or possessed. Like example, if I am selling this scale to you, I own this scale. So this is what beta, existing goods. Am I clear with this thing? It is owned by me at the time of sale. That is existing goods. Future goods. What do you mean by future goods? Like example, these are the goods which are neither owned or possessed by the seller at the time of contract. Example, goods to be manufactured. You came to me and you told me, sir, okay, I am a manufacturer of shirts. Okay, you showed, I had one shirt. You saw it and you liked it. You told, I want 100 shirts. So sorry sir, I don't have it now, but I can manufacture and give it to you. You told, okay, no problem. So basically, are these 100 shirts owned or possessed by me at the time of contract? Answer is no. So these are which goods beta? Future goods. Am I clear? Next is contingent goods. Contingent goods, basically these are also future goods beta, whose sale depend upon a condition, upon a contingency. If that contingency is fulfilled, then beta it's a valid contract, or else the contract is void. Let's take an example. Example, I am getting married. These are just example, keep it at the level of example. And my father-in-law, to be father-in-law, he told me, Arey, now this is not dowry, okay? He is like, okay, I am very lucky that I got a son-in-law like you. I want to gift you something like a father. Hello, what? Like, on the day of marriage, I am going to gift you a BMW. I told, I don't want it. He's like, no, you have to take it. I'm like, okay, I already have a car, I don't want it. Well, no, you have to take it. I told this thing to my friend, Mr. X. He's like, I told you this is what he's giving. So he's like, you don't want the BMW. No, do one thing, now you sell it to me. So I told, okay, I will sell the BMW to you, provided my father-in-law gives it to me. He just to make me happy, if he tells, yeah, I'll give you BMW and he did not give. So how can I sell it to you? So basically the sale between me and Mr. X is contingent upon my father-in-law giving the BMW to me. If he gives the BMW and I don't sell it to him, so basically he can sue me because it's a valid contract then. He can sue me. If condition is fulfilled, it's a valid contract. But in case my father-in-law only did not give it to me, so how can I sell it to you? So basically the contract between me and him becomes void. Am I clear with this thing? Understood? Great. Now, guys, existing goods are there. Existing goods. Existing goods are also classified, divided to three parts. Existing goods. Now, which are the three parts? How it is divided? How they are bifurcated? First is specific goods. Second is uncertain goods, and third is ascertain goods. Specific, uncertain, and ascertain. Let's understand what is this. But specific goods are the goods which are identified and agreed upon at the time of contract. Like example, I am selling this mobile. Okay, this is my mobile. Beta, and I am selling it to you. So you also know which goods I am selling. I also know which goods I am selling. So what is that, beta? Specific goods. What is that called, beta? Specific goods. Sir, uncertain goods. Now what are uncertain goods? Like example, I went to Royal Enfield showroom and I told कि I want one Royal Enfield, okay, classic 350 bike, black color. I did the paperwork, everything, and I went to see the bike. Now when I went to the godown, in the godown there are five Royal Enfield bikes, black color, Royal Enfield classic. Now basically these 5 bikes, do I know which is my bike? Does he know? No. So basically this is called as uncertain goods. Okay, the 5 bikes are called as uncertain goods. So goods which are not identified and agreed upon at the time of contract. Example, goods kept in godown in lot. Am I clear? Now ascertain goods. Now what do you mean by ascertain goods? Let's understand. But ascertain goods means, example, when we go to the godown, okay, 5 bikes are there. Now the seller better takes one bike out and tells me, sir, I am selling this bike to you. So they will take one bike out of the lot. Yes. Now this one bike is called as a certain good. Am I clear with this? Goods which are identified and agreed upon after the contract. That is speaking one bike out of the lot kept in godown. Did you understand? Clear? I hope you understood better. Existing, future, contingent goods and existing, specific, uncertain, ascertain goods. Okay. This delivery part, okay, I'll do in the 3rd unit, not now. Okay, this is very important for you to understand. Beta, under Sale of Goods Act, there are 2 documents which are very important documents pertaining to the goods. One is document showing ownership of goods, which we call as document showing title. What is document showing title? It is a document which shows the name of the owner. It mentions the name of the owner. Like example, RC book of vehicle, share certificate. It will mention the owner. Am I clear with this? Name of the owner. But what is document of title? Document of title does not mention the name of the owner, but it mentions the name of the person who can take possession of the goods. Like example, I had to send my bike for servicing, okay, to a showroom, okay, service center. I am in Mumbai, service center is in Bangalore. Okay, some major defect came. Now what I do, I hand over the bike to railway authorities because I can't ride that bike now. And railway authorities, I fill the form and then hand over the bike to them, and they give me a receipt. We call it as railway receipt. And they ask me whose name should I put on the railway receipt. Now I have to put the name of the person who will take possession of that bike there. So I asked the service center person, so Mr. M, he told, do one thing, put my name. So I will put in the railway receipt Mr. M's name. Now beta, when the train will go there and the bike will go there in Bangalore, at that time Mr. M has to go with his identity card and basically this railway receipt. I have to send this railway receipt to him. He has to show it and basically they will hand over the bike to him. Am I clear with this? So basically this railway receipt, does it show the name of the owner? No, it shows the name of the person who can take possession. Similarly, if you send the goods through ship, that is called as bill of lading. Understood? Document showing title, document of title. Next, price. What is price, beta? Money consideration for sale. Without price, can there be sale? I'm not saying price has to be paid at that time, but price should be there. Okay. Now, one interesting question, okay, came in CPT exam on this term property. We'll understand it properly. What is this? Sir, see, there are two types of property mentioned. These are legal terms. One is general property. General property means, beta, complete ownership, complete interest in the goods. It is with owner. And one is special property. Special property means limited interest, limited ownership, not complete. It is with pledgee. Now, what is this? Let's understand. See. Example, I had gold of 50 lakh rupees. So, can I say I have general property in the gold of 50 lakh? Yes. Now, but one day I wanted 10 lakh rupees. So, what I did, I pledged this gold to Vishnu, and Vishnu gave me loan of 10 lakhs. I told I'll repay after 3 months. Okay. So, I am the pledger, he is the pledgee. Now, tell me, until I repay the loan, can I say, beta, out of this 50 lakh, Vishnu has paid 10 lakh rupees on the gold. He is the owner of the gold worth rupees 10 lakhs until I repay the loan. So, basically, he has complete ownership in the goods or limited ownership? Limited. So, he has special property in the gold of 10 lakhs. Understood? Okay. So, basically, general property is with owner, special property is with pledgee. So, one question came in CPT. I'll ask you this question, you answer, okay? They can ask you in the form of case law. Sale of Goods Act deals with transfer of A. General property, B. Special property, C. Both A and B, D. None. Give me the answer. Okay, Mohit. Both A and B. Answer is A. General property. Beta, see, they just because they have mentioned what is general property, what is special property, Sale of Goods Act will not deal with that. The Sale of Deal Act will come whenever there is transfer of ownership, complete ownership, then only we'll call it as sale now. Pledge, in pledge, beta, limited ownership goes, and for pledge, beta, we have contract of pledge. It is governed under Indian Contract Act. So basically answer will be general property. Am I clear? Good. Very good, very good. Very good. Okay. Then, beta, okay. Now, after these points, beta, okay, there are some points, okay, there like distinguish between sale, agreement to sell, sale and hire purchase. You see, beta, recent papers, they are not asking you all these things. So basically in the crash course, I'm not touching, but as I told you, YouTube people, or you can just post it, sir, I want on that. I'll make a separate video and send and post it on YouTube. Okay, you can watch it, no problem. Now, one concept is the destruction of goods. Sir, during contract of sale, if the goods get destroyed, who will bear the loss? Okay. So for that, beta, okay, they have put it into three parts, three circumstances. Sir, destruction of goods before entering into contract of sale. If the goods are destroyed, okay, before entering into contract of sale, okay, unknown to the buyer and seller, if the goods get destroyed, then what will happen? Second, after contract of sale. After the contract is entered. Third, beta, after agreement to sell, but before sale. Agreement to sell is done, but before agreement to sell converts into sale, before that goods are destroyed. I'm telling you, probability will be very less. Okay, they generally don't ask all these things. Okay, that's the reason. I'm telling you, this time paper was easy. People are selling this time paper was easy. September attempt foundation. You found that different distinguish between, or else they would not ask you that much. Okay. Now, understand, sir. Destruction of goods before contract of sale. I'll put it in a very simple point. Okay, very simple point. Just for understanding. Okay, I don't demean anyone. Example. Samiksha, are you there? If yes, just give me a thumbs up. Okay, so I'll just ask you a question. Give me blank answers. Okay. See, example, you are about to get married. You got the photo, and this is for everyone. It is for boys also. Okay. You saw the photo, okay, and you like that person, and your parents are like, tomorrow we'll go to see that boy. Now, better, before you see him, tonight he might with an accident. Okay, both hands are cut. Example, he loses both hands and both legs. So now, beta, will you go ahead with the marriage? Yes or no? Yes or no? No, obviously not. So if the before contract of sale, before entering into contract of sale, if the goods are destroyed, okay, so basically the agreement is void ab initio. Okay, who's the owner, beta? Seller is only the owner. Ownership is not transferred, and seller will take the loss of the goods. But beta, example, you got married, after 2 years this incident happened, then you will take divorce, or basically you will continue the marriage. Continue or discontinue? Please continue. So obviously, beta, after the contract, once sale is done, ownership is transferred to buyer. After that, anything happens to the goods, so who will bear the loss? Buyer. Okay, so basically contract is valid. Seller, who will take the loss? Beta, buyer will take the loss. Okay, but example, after agreement to sell, but before sale, you got engaged. Marriage is after 1 year, 2 months after engagement. Okay, if this thing happens, you will continue, go with the marriage, or you will discontinue? Not you or your parents also, discontinue. Yes or no? So basically, okay, if agreement to sale is done but ownership is not transferred, before that anything happens to the goods in between this, so basically the contract is void. Okay, loss is with the whom, beta? The seller. Seller will bear the. Understood properly? Clear? Simple? Yeah. Sure. Okay. Now, okay. Now, this is an important topic. What is this topic? Fixation of price, section 9 and 10. Guys, I told you now, say price is important, but when it is to be paid is not important. But without fixing the price, can there be a sale, contract of sale? No, price is to be fixed. But basically, who will fix the price and when the price will be fixed? That section 9 and 10 gives me answer. So basically, sir, who will fix the price? Price is fixed as per the intention of parties. Very important. Parties will decide the price. Now, when will they decide the price, beta? Answer, beta. They may decide the price at the time of contract. Like when you buy things in shop, at the time of contract, price is fixed. Second, beta, price may not be fixed at the time of contract, but it can be fixed as decided by parties. Maybe, beta, during the course of contract. Okay, like example, price can be fixed by any method mentioned in the contract. Example, in the course of dealing, like in the case of gold, silver, etc. This is for those goods, beta, whose price changes every day. Like example, Mr. X sold 10 kg of gold to Y today. Today's price example per gram is 12,000 rupees. Now, but how the contract will be done now? One shot better 10 kg of gold will not go to wife. They have agreed that every day half kg of gold will be given by X to Y. Now X is thinking, if tomorrow the price goes to 13,000, then it is my loss. I'm selling for 12. Y is thinking, tomorrow price goes to 11,000, then it is my loss. So they are not fixing the price at that time. What they are telling? Everyday market price of the gold changes. Now, so whatever will be the market price, that will be the price, every day's price for that half kg of gold which is delivered. Is it okay? Yes, it's okay, no problem. Next, third point is, sir, buyer and seller can enter into contract of sale. Today we are entering into contract. I am selling, example, Harsh is selling, okay, I have a Rolls Royce car, very antique car, my grandfather's, okay, to Mr. Y. But better, it is an antique. We don't know the price. So I have transferred the ownership, sale. Who's the owner beta? Y is the owner now. But we decided beta, the price will be decided by X, an expert, third party. Now what, as we have entered into contract, have transferred ownership, whatever price he will decide will be final or not. Yes, obviously. But so basically now what happened, whatever price he decides will be final, section 10. But example here, he decided price as 50 crore. Now beta, why is like, no, 50 crore I cannot pay. I thought it is 20 crore only. So I don't want the contract. I don't want the car. Can he give the car? No. Then he is committing breach of contract. I can sue him for damages. If beta Y does something or I do something because of which beta expert is not able to value the goods, party doing that wrong thing, chichi thing, will be liable for the other party. Okay. But example, it is so antique that beta expert is also not able to decide. Then what will happen? Will the contract be void or it will be valid? Depends upon beta, depends upon whether the buyer has used the goods or not. Example beta, buyer has not used the goods. I transferred ownership, but that car is with me only. And expert did not decide the price. So obviously contract becomes void. Okay, because he failed to decide. But if buyer has used the goods, I given the car to him also out of trust. Now beta, he is not able to decide the price. Now if the contract becomes void, it is my loss because the value would go down because he has used the goods. So here buyer has to pay a reasonable price. Am I clear? Section 9 subsection 2. So from all these things I understood that price can be decided at the time of contract, during the course of the contract, while performing the contract, or after the contract also. Am I clear with this thing? Understood? Okay. But it is a valid contract. Did you understand? These were the main points. One more point is stipulation as to time and all. Okay, that will be done in unit 2. Clear everyone? This was unit 1. If you understood, give me a thumbs up. Give me a thumbs up quickly. Good. Very good. Now, okay, the unit 1 is done. Now we'll go to unit 2. I think 100% one question will come from unit 2. 100%. Okay. Now let's understand what is unit 2. It's an interesting thing. A small part, but yes, in an interesting part. Let's understand. What is this? Sir, unit 2 talks about conditions and warranties. What does it talk about? Condition and warranties. Just a second, I'll have what. But it is filled. All of you are JKSC students itself or non-JKSC? Any non-JKC student, give me a thumbs up. Any non-JKC student? Oh, all JKC students. Okay. Now we'll go to unit 2. See, now we are starting with conditions and warranties. Now what is conditions and warranties? Sir, conditions and warranties. These are Karan Arjun, brothers from same mother. What is the mother called? Stipulation. Now what is stipulation? I have written important statement concerning a sale or important requirements under a sale. Like example, if I am a seller, guys, and I am selling my goods, so I will talk good things about my goods. Like these are the best goods, okay, the best goods in town, the most hygienic. Example, I'm selling mangoes. I'm like the best mangoes you'll say, see, you can find the sweetest mangoes, the most hygienic mangoes, most nutritious mangoes. I'll tell like that, obviously. Okay. But beta, will I tell now the negative things? Oh, the worst mangoes, okay, the most unhygienic mangoes, poorest mangoes. No, I'll not tell this thing. So you know, as a buyer, I will, as a seller, I'll tell good things about my stuffs. But there are certain statements, certain qualities which I tell about the goods. Okay, listening to which beta you decided to enter into contract. Those important statements are called as stipulation. Okay, am I clear? Like example, beta, I am telling you wanted beta, okay, Alfonso mangoes. I'm telling these are the best Alfonso mangoes. You are like, acha, is it Alfonso? I'm like, yes. Just because it is Alfonso mango, you decided to buy. So what is that beta? Stipulation. Am I clear with this thing? Important statements requiring a sale or important requirements of a sale. Okay. Now, beta, stipulation can be a condition or it can be a warranty. Now, what is condition? Condition is the most important stipulation in a contract of sale. This is the basis of the contract. This is that quality which the buyer wanted in the goods because of which he entered into contract. If he doesn't get that quality in the goods, will he enter in? Is there any use of buying that goods? No. So in case there is a breach of condition, the buyer can cancel the contract plus claim damages. Like example, I am not giving you Alfonso mangoes. I am giving you sweet mangoes, but not Alfonso. So obviously, beta, will you buy it? Answer is no. Am I clear? Now, what is warranty? Warranty is also an important stipulation, but it is okay, secondary to condition. But it is secondary to condition. I'll make the changes and give it to you. Don't worry. It is secondary to condition. Means this is not the exact purpose why the person entered into contract. It is an add-on benefit. Okay. If this thing is not there, it will not be like the purpose of the contract is dissolved. No, the purpose is fulfilled, but yes, add-on benefit you are not getting. So here beta, if there is a breach of warranty, buyer cannot cancel the contract, but he can claim damages only. Like I'll give you example. The buyer told that boss, sir, buyer told the seller, I want white Honda City petrol car. Yeah. In clean state. Okay. Now beta, example beta, seller gives him black Honda City. Will he take it? No. That is a condition. White Honda City petrol is a condition. Now example, seller gave him white Honda City petrol. but a bit unclean. It was a bit unclean. Okay, can the buyer cancel the contract? No, because beta what he wanted it was there, but yes, he wanted in clean state. This was warranty. He cannot cancel the contract. But beta example, the buyer beta goes take and cleans, take interior cleaning and all he did of the car, take an exterior cleaning. For that he incurred 10,000 rupees. So can he claim that 10,000 from the seller? Answer is yes. Am I clear with this? Understood? If you understood, give me a thumbs up. Give me a thumbs up. Yes? Okay. Good. Okay. Now, this happened with me once. I'll tell you actual practical case. I purchased a pre-owned car. Okay. So basically, that implied condition is like how, like when I saw the car, okay, I did a bit of small ride, okay, and it was good. So I told, okay, I'll come after 1 week and you give me the car. Well, okay, I took the car and it was the same car, obviously. Okay, but when I drove, okay, above 100 kilometers per hour, at that time it was not getting that pickup. So I told him, what happened at that time, beta, okay, the air filter, okay, it was a pre-owned car. The air filter, okay, had to be changed. Now tell me, can I cancel the whole car? No. But beta, okay, the air filter, can I tell him to give me the new air filter? Answer is yes, beta. The damages he can give. The air filter is hardly of 500 rupees. So he had put the air filter new and then basically the car is running properly. So basically, can I cancel the contract here? No. Did you understand? Yes. Simple. Okay. Now beta, understand. See, when I'm teaching you all these things, you're attending the lecture. So by the time I'm teaching you all these things, beta, there are many buying and selling happening in the stores. Okay, people are doing business. Yes or no? We are doing our business. So you know better what is condition and warranty. So example, beta, if tomorrow you are handling your own business and you're buying some stuffs, you can mention to the seller, this is my condition, this is my warranty. Yes or no? You know that thing. But better tell me, do the outsiders know now? Who has not done CA foundation? They don't know. And that's the reason beta lawmakers tells that boss, not everyone knows what is condition and warranty. That's the reason it is the duty of the lawmaker to protect the interest of the buyers. That's the reason beta the lawmakers under Sale of Goods Act have put certain conditions and certain warranties. This is for the protection of whom beta? For the protection of buyers. And as law has put it, because these are called as implied conditions and implied warranties. If you tell this is my condition, this is my warranty, that is expressed. But basically, if the law has put conditions and warranty, that is called as implied conditions and warranty. And law tells that in every sale of goods, okay, in every transaction, this implied conditions and warranties should be there unless expressly removed by the seller and buyer. Okay, so see, what is the first one? Implied condition. If there is a breach of implied condition, okay, buyer can cancel the contract and claim damages. You know this thing. Okay. Now see, first is implied condition as to title. Title means ownership. Sir, if I sell some goods to you, you are buying it. What is the purpose? You should get proper ownership. If you are not getting proper ownership, can you cancel the contract? Yes. When will you get proper ownership? When the seller has proper ownership or seller does not have proper ownership? Answer is seller has proper ownership. It's an implied condition that the seller should have proper ownership. So see, seller should have proper title on goods, only then he can confer, that is give a proper title to buyer. Example, A had stolen a mobile and he sold that mobile to B. Okay, will B get a proper ownership? No. Can B cancel the contract? Yes. Okay. Next, implied condition as to description. Now example, this tells beta whenever goods are sold by description, the goods must match the description. Example, that is section 15. Example, I purchased some bike on OLX and it was written but it is a 200cc bike. So it should be 200cc engine capacity. But when I got the delivery, I understood it is only 100cc bike. Can I cancel the contract or not? Yes, because the goods did not match the description. Like it is like example, beta, you are going and you are buying a coconut for water. Okay, so basically you are tell him, give me a coconut which has water, not that malai. We say malai. He gave you but a coconut which had less water but lot of malai. Will you take it? No. Goods did not match the description. Okay. Now, implied condition in case of sale by sample. Section 17. But sometimes goods are sold by sample. Like I show a sample to you. Okay. You see the sample and basically like I'm selling this wallet. And by looking at the sample, beta, verifying the sample, you order bulk. Tell me, should the bulk match the sample or not? Obviously, yes. It's an implied condition that the bulk should match the sample. But certain extra implied conditions are there here. What are that extra implied conditions? If you are the buyer, when I give you the bulk, you should have an opportunity. I should give you a reasonable opportunity of inspecting whether the bulk matches the sample or not. Second, there should not be any latent defects. Latent defect means defects which cannot be seen by naked eyes. Like I showed you woolen gloves. It's so cold na here in Bangalore, everywhere I think. So I showed you woolen gloves. You saw the sample, ordered 1000 pair, and you told black color woolen gloves. I gave you. But it was black color. It was as per the sample. So you accepted the bulk, and now you wore one pair of woolen gloves, and you are driving. Now after some time, you started feeling something itching. And basically, beta, then when verification was done, there were white ants which cannot be seen, okay, by naked eyes. Small. Yeah. So tell me, okay, now beta, the contract is valid or void? Void, because beta, it had latent defects. Understood properly? But example, if I would have given you beta, rather than black woolen gloves, grey woolen gloves, then too you accepted it. That is patent defects. Now can you cancel the contract? Am I clear with this thing? The bulk should meet the sample plus other conditions. Opportunity of inspection should be given and there should not be any latent defects. Clear? Now, condition as to sample and description. Sometimes goods are sold by sample and description. Like I sell this wallet to you, I show the sample and I describe it. Pure leather. Okay. Basically 3 compartments are there. Hand finished. Yes, like that. So tell me, and you basically you order the bulk. So here goods are sold by sample as well as description. Now beta, goods should match both sample as well as description. If anything is not fulfilled, buyer can cancel the contract. So see example, if goods are sold by sample and description, both conditions should be fulfilled. Now example, Mr. A showed a bottle of oil to B and described it as pure coconut oil. Pure. Okay. Some people say pure. I say pure. Some people say pure. So that is pure coconut oil. We saw it and ordered 1000 bottles. But when he got the bottles, now later on he understood that boss, that 1000 bottles are as per sample. But it is not pure coconut oil. It is a mixture of coconut oil and sesame oil. It matched the sample, but did it match the description? Ille. So can the buyer cancel the contract? Answer is yes. Okay. Understood? Everyone? This is star mark. This will come in your exam directly, indirectly. Probability is very high that it will be asked. So see, what is this? Condition as to quality of goods as fitness for use. Okay, as or fitness for use. Section 16. This is actually caveat emptor. Now understand this concept. See, when I sell the goods, I as a seller, I'll be selling different quality of goods. Yes, different quality of goods I'm selling. It is whose duty to see whether the goods which you are buying is fit for your purpose? You, buyer. It is whose duty to see that boss, take the quality of goods which you are buying meets your requirement? It is you. If you did not, you selected the goods negligent, is it my mistake? Answer is no. That is caveat emptor. Let the buyer be aware. Am I clear with this? Okay, we'll take an example. Example, I have flat foot, and for flat foot, okay, I go to Skechers showroom because they have shoes for a flat foot. Now there are different shoes kept. I selected one shoe because I liked it. It was light and all. Okay, and I purchased it. Tomorrow I come to them and I tell, sir, this is not a flat foot shoe. Okay, I want to cancel the contract. Give me another goods. Will he cancel the contract? No. It is me who selected the wrong goods. But in case I had told him, sir, I want a flat foot shoe, then too he gave me a wrong shoe, then better it is whose mistake? His mistake. Okay, I told that boss, take an example, I am buying vegetables. There are different qualities of vegetable. Okay, I told him, sir, I want good quality of vegetables, give it to me, and he intentionally gives me wrong quality, inferior quality. So basically it is whose mistake now? His mistake. Am I clear? There caveat emptor will not come. Did you understand this thing? Understood? Yeah. So see, generally there is no condition as to quality of product or fitness of product. Buyer has to assure the goods, that is caveat emptor. Let the buyer be aware. Okay. Exceptions where beta caveat emptor will not come. Buyer inform the seller about the case, okay, about the use, and second, buyer relied on the skill and judgment of seller. Okay, I told him that what use I want, and then too he gave me wrong goods. So basically it is his mistake. Am I clear with this? Next, condition as to merchantability. Merchantability means sellability. Tell me, if you are buying the goods from me, what is the purpose you are buying the goods? Now tell me, either you will buy it for using it or reselling. So can I say that the goods should be of that quality that it can be used as well as resold? If it is of neither of the quality, so basically is there any use of buying the goods? No, buyer can cancel the contract. Am I clear? And claim damages. Understood? Clear, everyone? Goods should be of the quality that it can be used or the resold. Okay. Like example, I purchased a pre-owned mobile. Okay, a refurbished one. Okay, from Amazon. Okay, this is not example. Basically, I was using it. Okay, and then basically it was continuously hanging on. Okay, hang. Okay, every half an hour it goes for it gets hanged. So basically, is there any use of this mobile? Can I use it? No. Can I resell it? No. Can I cancel the contract? Obviously yes. Understood? Next, condition as to wholesomeness. Now this is for eatable products. Okay. Out. This is, it won't hang obviously. Now see, it is for eatables. Last one is only for eatables. So question is, like example, you went to have a samosa, okay, and it is a eatable product, so it should be of that quality that it can be consumed, correct? Now you opened examples one samosa, okay, you had one gulp, okay, you didn't open, you had one gulp, and then the moment you had one gulp, two small cockroaches, baby cockroaches, okay, ran on over your hand. Tell me, if you had it, okay, and basically food poisoning happens, so basically, okay, can you sell the seller? Can you sue the seller for that hospital expenses? Obviously. Am I clear with this? Has anything happened to you like this? Anyone? No, na? Obviously not. Clear? Forget about this also. Like example, you are having food and basically one big hair comes. This might have happened. Okay. So basically, can you cancel that contract? By take it away? Obviously yes. Okay. So now did you understand? So this were the implied conditions. 7 implied conditions are there. Okay. Sixth one is important. It is related to caveat emptor. So So actually caveat emptor is important part. So I'll read it again. Okay, separate pointers of caveat emptor is given, so we'll read it properly. Okay, then we'll go for implied warranties. Let's see. The caveat emptor I am reading properly because probability is very high, it can be asked. Caveat emptor, section 16. Caveat emptor is a Latin expression which means let the buyer be aware. The doctrine said generally seller is not responsible for bad goods. Who is responsible? Buyer. This doctrine takes the side of the seller. As per the rule, seller is not responsible in the following cases. To know the particular purpose of buyer, if buyer chooses the goods negligently, if the goods are defective and defect is patent, like I'm buying this mobile and there is scratch on this, okay, crack, then too I purchase it. So obviously it is my mistake? No, it is basically I'm selling the mobile to you and there is a crack, okay, and then too you purchased it. It is my mistake? No, it's not my mistake, it's your mistake. Yeah. When the goods are purchased under some brand name, like example, I told the seller, give me Amul milk, consumable, and basically he gave me Amul milk, the shopkeeper. Now that because of Amul milk I had a food infection. Can I sue the seller? No, I have to sue the brand owner. Am I clear with this thing? The seller is not responsible for that. Am I clear with this thing? Okay. Now, but in two cases, beta, okay, but there are exceptions. Okay, here, beta, buyer be aware, okay, will not come. Seller is responsible. Where the buyer specifies the particular purpose, I told you. I told that I want flat foot, shoes for flat foot. Then to beta seller give me wrong goods. It is his mistake. There is a case law, Bombay Burma Trading Corporation Limited versus Aga Mohammed. Here one person got the contract of making sleeping berths in railway compartments. You know, railway compartment, there are sleeping berths. Okay. So this guy, example, I am that person. So I ordered timber from a seller and I told him that I want timber for making railway berths. He should give me hard timber, good quality timber. He gave me very soft timber. Okay, so people if they sleep, okay, it will be it will get broken down. So basically, can I cancel the contract? Yes, because even after telling the purpose, he gave me wrong goods. That is the point. Okay. Second, buyer relies on the seller's skill or judgment. I told give me good quality of vegetable. Then to seller gave me wrong quality. So it is his mistake. Where there is a contract of sale by sample, okay, the rule will not apply if goods do not correspond with sample. I purchase goods, okay, bulk by seeing the sample. Bulk should match the sample. If it did not match, seller is responsible or buyer is responsible? Seller is responsible. Caveat emptor will not come. When goods are bought by description, goods shall correspond to the description, or else seller is responsible. Caveat emptor will not come. If goods are bought both by sample as well as description, this rule will not apply if goods do not correspond with both. Yes, there is an implied condition that the goods should be of merchantable quality. Where seller actively conceals some defect in the goods so that the same could not be discovered by buyer on reasonable examination, then the rule of caveat emptor will not apply. Yes or no? Basically, example, there is a defect in the goods. Example, I am buying a car, it's an accidental car, and basically the seller intentionally conceals everything, repaints everything. Okay, then better, and I told him I don't want an accidental car, but he intentionally conceals so that even on reasonable examination I will not find the fact. Basically, later on, can I sue him when I understand that boss he sold me a accidental car? Answer is yes. Am I clear with this? Understood? properly? Yes, this will happen more when you buy good cars and all from Delhi. If you go to Delhi, beta, okay, you will get very cheap cars actually. But basically, many people are there, not Delhi people, but many people who are into that business. Okay, they sell almost all cars are accidental. So if a car you find it for 15 lakhs, you will get it there for 7-8 lakhs. But basically, they will conceal the defect like that. So basically, caveat emptor will not come. Am I clear? Understood? Okay. So we have finished beta implied conditions. Okay. Now, sir, what is the next one? Implied warranties. Now, yes, there are 4 implied warranties. First is implied warranty as to quiet possession. Warranty is secondary to condition. So here party cannot cancel the contract but can claim damages. Next, implied warranty that goods should be free from encumbrances. Third, implied warranty to disclose nature of dangerous nature of goods. And fourth, implied warranty as to quality of goods as per usage of trade. Okay, so let's understand what is this. But first two things I have one example. I'll explain you with by one example only. Okay, understand this example. Let's see, I'll explain it properly, the meaning and all. Example, there is a guy, Mr. Kejriwal. What is his name? Kejriwal. Not politicians and all, I'm generally taking. Okay, don't drag me into politics, sorry. He had a bike called as Hayabusa. Okay. One day he was in need of loan. What he did, he gave the bike, he did not give, he took loan from Mr. Modi 1 lakh rupees and hypothecated the bike to Modi. Now what is hypothecation? It means beta owner will be Kejriwal, bike will be enjoyed by Kejriwal only, he will only ride. Okay, the loan was of 1 year, but after 1 year, if Modi doesn't get the money back, so then Modi will take the possession of the bike, not ownership, possession. He will ride the bike. Am I clear? Until the loan is repaid. So basically this is okay. Now tell me, the bike is free from encumbrance. Encumbrance means charge, control. Free from encumbrance, or it is under the encumbrance of Mr. Modi? It is under the encumbrance of Modi. Okay. Now, after 6 months, Kejriwal was in need of more money, loan, 15 lakhs. So what he did, he sold the bike to Mr. Gandhi. Okay. Now tell me beta, will Gandhi get a proper ownership? Yes or no? Yes or no? What do you think? Yes or no? Answer is yes. He will get a proper ownership. Because who's the owner? Beta Kejriwal. Kejriwal is the owner. Okay. So one owner can give a proper ownership. But did Gandhi get a bike which is free from encumbrance? No. It was under the encumbrance of Modi. So there was a breach of warranty. Second one. Okay. Now, the first the breach of warranty was done. Now after 1 year, when the due date came, Kejriwal failed to pay Modi. Modi told, give me the bike. He told, it is with Gandhi. Now Gandhi, okay, Modi went to Gandhi and like, can I see the bike just for a second? Sir, take it. So when he sat on it, he's like, hey, boss, now forget the bike. Okay, I will ride the bike. But he's like, Gandhi's like, I am the owner. But you are the owner. But we have a contract that if the loan is not repaid, I will ride the bike. I will enjoy the bike until the loan is repaid. Now tell me, beta, did Gandhi get a proper ownership? Yes. But did he get proper possession? Answer is no. Gandhi is like, what will I do with the possession with the ownership? I want the possession. Basically, Modi is like, my 1 lakh is paid, then I'll give the bike. Now, what Gandhi does? Okay, can Gandhi sue Kejriwal for cancelling the contract? No, because it is breach of warranty, not breach of condition. But beta, example, Gandhi took a loan from a bank with 10,000 interest and of 1 lakh and gave it to Modi. Can Gandhi beta sue Kejriwal for that 1 lakh 10,000? Answer is yes. He can sue for damages. Am I clear? So can Gandhi sue for 1 lakh paid? Answer is yes. Am I clear? Understood? And also the interest, obviously. Okay, I hope you understood both the cases. Okay, sir. Next, implied warranty to disclose dangerous nature of goods. Now, what is this? Sir, in case there is a goods, there are some goods which are of dangerous nature. So basically, it is an implied warranty that the seller should mention it to the buyer. If he doesn't mention it and the buyer faces some loss, beta, seller is bound to compensate the loss to the buyer. I'll give you an example. Like if you, like many of you might, like you are watching from your home. Okay, you might be brushing your teeth and watching. Many of you. Okay, so just see the toothpaste. On the toothpaste, generally it is written not for children below 6 years of age. Why? Because it is chemical. If a child less than 6 years, because their gums are very raw, that might damage their gums. So if the seller doesn't tell it, and basically any buyer uses, he gives it to his son who's 5 years old, and his gums get damaged, can he sue? Can the buyer sue the seller? Answer is yes. Seller means basically the toothpaste company. Answer is yes. Am I clear with this? Understood? Clear? Sometimes if you see any medicine and all, buy some medicines, and basically it is written on that. Okay, store in a cool and dry place. Don't expose it to sun and heat. Why? Because it is a chemical. It will react. If they don't mention it, beta, okay, then beta they are liable for the damages. Understood? Clear? This McDonald's was the anti case. It actually happened. Okay, like if you see McPuff in McDonald's, there's a item called as McPuff. Okay, initially that McPuff was very hot, and even my tongue was burnt. I still remember as in 6th standard. So what happened? One lady, beta, she had this McPuff. Okay, and it was very hot, and her tongue got burnt. She filed a case. Actually, she filed a case under Consumer Protection Act, but you can file under Sale of Goods Act also. It is dangerous nature of goods. Many small children have McPuff. It might burn their throat. So basically, you should mention it. So that lady got compensation of thousands of dollars at that time, like 20-25 years back. Okay, that's the reason now, beta, they mention on MacPuff and all. Okay, wherever it is hot, okay, it is hot. They mention on the packages like that. Understood? Next, warranty as to quality of goods or fitness for use. Okay, as per usage of trade. Now, what is this, beta? In India, there are many businesses, many trades going on, and every trade and business has some customs. So if the customs of a business tell that boss, if seller is selling goods to buyer, it should be of this particular quality, and if it is of not that quality, then beta, buyer can sue the seller for damages. Like example, Mr. X is selling gold to Y, and that Y is a goldsmith. Now it is implied, okay, that in this gold business, if you are selling gold to goldsmith, it should be 24 karat gold, because then only beta goldsmith will be able to make 22 karat gold ornaments. Okay, but beta, this was not specifically mentioned to X, because why assume that X knows, and he should know because he is in that business. But what he does now, he is new to the business, he sends only 22 karat gold, because of which Y cannot make these 22 gold ornaments. No, he can't make. He can only make 18 karat gold ornaments. Now, because of this, if there is any loss to Y, beta, he can sue X, okay, for that damages. Am I clear with this thing? Understood properly? Okay. Good. Now, so the implied conditions are done, implied warranties are done. Okay. Now, one point is there in Sale of Goods Act. This question had come in exam earlier. Only one point is left. When can a condition be treated as warranty? Section 13. Now, question might not come like this. When can a condition be treated as warranty? They might ask like, when can a breach of condition be treated as breach of warranty? Or when can a breach of condition, or when will a breach of condition sink to the level of warranty, like that? I'll explain this thing. Give me 5 minutes, I'll explain properly. Okay. Example. Amiksha, are you there? Yes or no? Yes or no? What's this? Yes or no? Well, Anish is there, Anish? Anish is there? Well, Anish, I'll ask you a question, okay? Now understand this. You tell me yes or no, just that's it. Anish, in case you got married, forget of married, okay? In case you and your brother enters into a fight and your brother slaps you, okay? Now he slapped you. This is called as battery as per Indian Penal Code. Okay, what do you call battery? But if blood did not come, okay, but anyone committed battery against you, example, I'll not go into that. The punishment is that if you sue him, beta, punishment is 6 months jail. If blood did not come, but if blood comes, beta, you can sue him, okay, for half murder and basically 3 years jail. Make clear? Now, example, your brother slapped you. Blood did not come. Can you go to the police station and tell, I want to sue him for half murder? Yes or no? No, obviously not. So basically, if blood did not come, just a simple battery. It's a small offense. You cannot treat a small offense as a bigger offense against you. But example, beta, if he hit and blood came, you wanted to sue, you have a right to sue him for that half murder, but you want to just file a suit for battery against him. Brother, hai na, 3 years jail, 6 months jail. Can you do it? Yes or no? Yes. So can I say, beta, if a bigger offense has happened against you, has been committed against you, you can treat it as a smaller offense. But can you treat a smaller offense as a bigger offense? No. So, breach of condition. Just a second. Just a second. Just a second.